Okay, so this is the second chapter, the second topic. This is the sources and understanding Islamic law. So, actually, what it has is the origins, sources, and how Islamic law actually developed, and what's the main premise of Islamic law. This is the second chapter of the module guide, and it's like sources of Islamic law, right? Okay, so the overview and the introduction I already gave, but to be specific, so in Islamic law, the sources would be the primary sources and the secondary sources. In primary, we say Quran and Sunnah. So that is the word of Allah and the words that the Holy Prophet said. So that's the things that he did were Sunnah, and the Hadith are the words he said. So that's Quran and Sunnah. Those are the primary sources, then we have the secondary sources. So we understand that these are like the sources of Islam, right? Islam and Islamic law. Okay, so we've already a bit discussed that there was pre-Islamic Arabia, that was the time of Jahiliyyah. So the age of ignorance is what we say that is the pre-Islamic Arabia, and it was categorized by tribal societies with no centralized governments, and the tribes had their own customs and own traditions and own laws, and they could do whatever they want, and there was no law per se, and that's the reason we say it as the age of ignorance, because they were ignorant in their practices. So anything was available for them to do, or they could worship anything, they could worship a rock, or they could worship the sun or the moon, or you know, complete the age of ignorance. That's then we say emergence of Islam. So the emergence of Islam is in the 7th century AD, right? And so that's when we say that there's a shift in the Arab society, that there's a shift in Arabia, right? So Islam provided a new framework for society, and based on their teachings of the Quran and the Holy Prophet. So, you know, um, so there's like a shift, the emergence of Islam. The Quran is actually after the leaving of the Holy Prophet from the world. That's when the Quran was compiled. But the Quran was revealed to the Holy Prophet during his lifetime. So during his lifetime, the Quran was revealed, and that's how he conveyed the word of Allah. But it was compiled later, right after his passing away. And the Hadith, that's the last. So the Hadith is the word of the Prophet himself. So that's numerous things that what he would say are the hadiths, and his actions are the sunnahs. So they give us light. So that's the origins of Islamic law in a very short and brief manner. Okay, so we will actually go into the sources further, because we get questions on the sources, right? So the primary source is the Quran. So let's start with the Quran. I think I'll have to go back and forth with a slide here. Yeah. Okay. So the Quran is the direct word of God, that's Allah, and it was revealed through the angel Jibreel, and Gabriel in English, to the Holy Prophet over a period of like 23 years. So that's written. This is an extra bit of information for those who want the brownie points or something. So the Quran contains 6,219 verses, and which are divided into 114 chapters. Now you can write that down. Furthermore, there are nearly 600 verses that deal with legal matters. So, how do we get law from Islam is because Quran itself has nearly 600 verses where legal matters have been talked about. So, for example, for the law of contract, there is verse 5:1, right? That's chapter 5, verse 1. O believers, abide by your stipulations. Now, what this verse is, it's talking about your contracts. Um, it's not necessary for anyone to like divulge a lot in it, but maybe just give a brief, a small explanation to it that, oh, believers, abide by your stipulations is abide by the contracts that you set up with one another. That's literally it. That when you make a contract, when you give your word, so you have to abide by them. You have to keep your promises. You have to keep your word. So, Quranic verses have been classified into following categories, right? Because as I told you before, Quran was compiled later. Though it was revealed earlier during the time of the Prophet, it was compiled later because then it became a thing that people realized that, okay, if we don't spread it, write it, or compile it, or let others know, that no one would know about what the Holy Prophet said, that's the Hadith, or what he did, that's the Sunnah, or the word of Allah, that's your Quranic verses. So nobody would know. It will be forgotten, or people will not remember them, or or it could be misconstrued as well because it can become a Chinese whisper, and you don't want that. So it was compiled later, and so we're just classifying them into categories. So there is first is Kati definitive, so that where there's no ambiguity, no room for interpretation, and the when where the verses are concerned, and these verses are as it is. They're like, so we have in LSM, for some who might have read this, it's for the legal system and method. The simple rule is that it's clear, it's cut, it's there, and it's simple, and that's how it is. There's no ambiguity in this. Second classification is zanni, or speculative. These verses are slightly ambiguous, and thus there's a bit of room for interpretation. Now, these verses are ambiguous, but that does not mean that they're wrong. Some of us have sometimes thought that these verses are wrong. They're not wrong. What they are is ambiguous. So um, it's not straightforward, it's not clear cut. There's ambiguity, and because if there's ambiguity in a statute, if there's ambiguity in a word, there's an ambiguity in this verse, so there's room for interpretation. One may say elevate. So there is one of the Quranic verses that come to my mind is it's a verse regarding the holy book itself, and it says that something along the lines of that elevate, the holy book. Um, Unfortunately, some people have considered that verse to be that you elevate or you pick up the holy book and you keep it up, but that's not how it is. You elevate the holy book as in one may read it at that manner, and one may read it in the manner that you spread it, you read it, you understand it, you spread it to other people, you elevate what the holy book says. You elaborate, you work on it, you understand it, you elevate the status of it, right? Because you give it that importance, not like elevating it as in lifting it up, literally. So that's interpretation for you. The third is or journal. These verses are open to interpretation again. These are journal verses, they are open to interpretation. Then there's khas or particular. These verses are on particular subject and there is no room for interpretation. Now, again, these verses would be for a specific topic, like we read the verse 5:1, O believers, abide by your stipulations. So this is a clear, I'd say, Kati definitive, and this is Kati and Khas because it talks about one specific subject and one particular subject, which is contract, and it's like definitive verse. So that's how it is. Okay, there are some other pointers like the Quran was compiled during the time of Hazrat Usman Raziallahu anha. It is not completely certain, but predicted that when Quran was revealed, it was written on animal skin and shoulder blades of animals, and also memorized by the companions. So it was that's the premise that it was written on stones and animal skin and bones and whatever could be found at that point and whatever they could find, they would write it to, keep a record of it or keep a memory of it. So this is for Quran. Next is Sunnah. So the compilation and classification of hadith. So Sunnah is the acts of the Holy Prophet, right? And the Sunnah of the Holy Prophet is the other main source of Islamic law. Sunnah comprises of saying, practices, and tacit approvals of the Prophet. When we say tacit approvals of the Prophet, this means that the Prophet approved it, maybe by remaining silent and not particularly denying it, and in other manners and practices, he approved of what was going on. So Imam Shafi, he is one of the if you know this, there are books of Sunnah, so there's Imam Shafi and others. So he's one of the greatest and the early Islamic jurists, after whom the Shafi school of thought was named. And he held that the Sunnah of the Holy Prophet was as important as the Quran itself. So that is obey the kitab, i.e., the book, and obey the hikmah, that's the wisdom. So the Quran and the Sunnah would not contradict each other, rather, they would complement each other. So, and there's also this thing that if, mainly this is for Zaif hadith, that if there is a hadith and there particularly there's always in a Zaif hadith though, if there's a hadith which contradicts what the book says, so take the book, not the hadith, because that's just how it is. Now, hadith in particular is an oral communication traced back to the Holy Prophet. Okay, why do we say traced back to the Holy Prophet? Is because um, it's Holy Prophet who said it, right? That's the reason it's called hadith. The words said by Allah are verses in the Holy Quran. That's the Quran. When it comes down to hadith, hadith is the oral communication that the Holy Prophet himself said, right? So there's that distinction and that difference. And each hadith consists of two parts. The first part is the chain of the communication, that is isnad. I think I've written it. Yes, I have. So there are two parts. The first part is the chain of the communication, that's isnad, of the sayings of the Holy Prophet from first to the last informant, the people in the chain. So the first person to say, then the last person to, say it. So this shows the credibility of the hadith actually. Depends therefore to some extent on the status and credibility of the informants as well. So how do you know that this hadith is correct and that hadith is zaif, right? So I used the word zaif. Someone would say, what does zaif mean? That means weak. How do you know it? Is because you go through that chain of people for every single hadith over and over and over again. That's how you know something is credible and something is not credible. For example, okay, so again, let me first complete this. Then there is the second part of the hadith that concerns us from here. Let me just iterate it. So there is the second part of the hadith concerns the formal content, that's matan, of the saying or practice of the Holy Prophet himself, right? So the matan is in a way your actual saying or his practice, and your isnad is your chain of people. Now, the higher the grade of the hadith and the soundness of the hadith, or it's a good hadith, and so it becomes asan. That is the first one. The sound one, sorry, is asan, the top grade, the highest grade. Next comes the good grade. That's the middle one. That's hasan. Okay. And then the lowest grade credibility is termed as weak, that is Zaif. That is DAIF, that's Zaif. And that, okay. Um, there's always, of course, different interpretation in even considering hadith because there's different approaches to hadith. Um, One is from traditional perspective and the other is from a rational perspective. So these are the approaches of interpretation for hadith. These are two different, right? So the traditionals, which attach a lot of significance to hadith and sunnah and adopt like a lateral approach to them, even to the extent of considering that doors of ijtihad are closed. We'll learn what ijtihad is later on in this video, but that's how serious they take hadith to be, right? That's traditional for you. When you talk about rationalists, they consider sunnah to be important source, but they allow ijtihad and interpretations. So those are rationalists. Like you rationalize things, you say that no, there would be interpretations to it, there could be thoughts to it, there could be understandings to it. While traditionalists would be like, no, we have the Quran, we have the Sunnah, and that's it. We're not looking into it more. That is it. Every door, everything else is closed. So that's the approach for hadith as well. We talk about secondary sources. So in these secondary sources, now you'd see ijma, which is consensus, qiyas, which is analogy, ijtihad that we just talked about, that's the individual reasoning. Now you'll understand why they say that ijtihad are the. So there is this one particular question that really does come. The UL certainly loves it, and it's the are the doors of ijtihad closed? So if you understand how Quran, Hadith, and the secondary sources, Ijma, Qiyas, Ijtihad, and then Istisan, and people don't read them. These last two, that is Istihan and Istisab. People don't read them. I'd say read them, understand them, because this will help you in the answering of the question when it comes down to Ijtihad. And the question would be, are the doors of ijtihad closed, or what is ijtihad in modern day society, right? So giving modern perspectives, you'll say that it talks about individual reasoning and stuff. Anyway, so that's secondary sources. Let's start with ijma first, I guess. That's consensus. My people will never agree on an error. So that is a hadith of the Holy Prophet, right? Um, so this above mentioned hadith lays the essence that consensus can be done amongst people. So that's the Muslim Ummah. Because as he says that if people come together and they agree on one thing, then that will not be wrong. That's how ijma is. That's consensus for you. That's coming together, talking about one thing, and then agreeing to it. For ijma to be valid, there must be a consensus of the entire ummah. Now, here, when we say the entire ummah, um, that is not possible today. And see, that's a modern predicament, right? Um, because there's a very large population, and that means a society, a group of people will not agree on an error. That's how you can interpret this. For other schools of thought, ijma allows authoritative interpretation of Quran and Sunnah. It can also answer those questions that are not answered by the Quran or Sunnah. Only an interpretation approved by ijma is binding on Ummah. So that means, just any ijma or any interpretation is not approved, and only one which has been which has been done with the consensus of a large Muslim scholars is what we'll say. The Muslim scholars have sat down and come to this conclusion, and then that will be agreed upon, and then that could be binding on the Muslim Ummah. So in the earlier times, the ijma required the consensus of the entire ummah because there was not many people. Like there were many people, there were hundreds and thousands of people, but still you could come to a consensus. For example, um, the first companions of the Holy Prophet decided to, through ijma, that Abu Bakr should be the first caliph, right? So that was a lot of people agreeing that Abu Bakr should be the first caliph as well. So that is again, a lot of people, majority agreeing on it. As the Ummah grew in numbers, an ijma of this sort became problematic. Therefore, certain qualifications were added. These included the person must not be a minor or a lunatic or non-Muslim. Eventually, the right to participate was restricted to jurists. Since there was no single body of jurists, it was difficult to reach a consensus. Moreover, each school of thought had its own interpretation. Example, a Hanafi woman can contract her own marriage, but a Maliki cannot. So you see now, when I said that a group of people, it's a group of people, literally, like a school of thought, a society coming together and thinking that, okay, the Hanafi women can contract their marriage, but then the Maliki are like, no, we're not allowing that. So that's again, you know, coming together. So eventually, all school of thought accepted each other's opinion by relying on the following hadith. Difference of opinions amongst my people is a sign of bounty of God. That you need to have difference of opinion. You can't just be on the same page, which of course makes sense because that's just very stagnant and it wouldn't work. Because then just be conflict, a lot of conflict. Shia school of thought does not give much importance to ijma, as legal issues are resolved by authoritative directions from the imam, which is true. That's Shia school of thought is like if the imam says yes, it's yes. If the imam says no, it's no. So then again, these imams are in a way, qualified jurists, and then they come to a conclusion. Okay. The next is qiyas, that's analysis. So this source depends on individual human judgment instead of collective judgment. The judgment must be in reference to the Holy Quran or Sunnah and is deduced by analogy with existing legal principles set out in the Quran or the Sunnah. You can't make a judgment, and of course, it can't be done. You can't make a judgment and come up with a judgment being like, okay, this is how I want things to be. Like, this is gonna be in red color, and that's it. when the holy book says something else. So, if there is some silence regarding some very specific matters, so you will have to apply your own mind to it as well, because that's how it is, and that's one of the principles of Islam, that you have to keep your mind open, and you have to apply, there's application of your mind is necessary in Islam. Next is that ijma and qiyas are regarded as third and fourth sources. Consequently, they are non-divine sources, which is important to note that these are non-divine sources. These are human analogy, human perspective, human consensus. And qiyas is limited to Islamic schools. For example, prohibition of drugs. Islam prohibits wine because it alters the state of mind. By analogy, drugs are also prohibited because they have a similar effect. You know, if there is prohibition on wine, why is wine stopped? It's because it alters your state of mind, and you're not, you know, in your state of mind, or your actions would not um, you might not take accountability of your actions, or you might not take accountability of your words. And if that's the same reaction, it occurs when you have other alcohol, so that means that alcohol is also not allowed for you. Now that's an analogy, that's an interpretation, and that's for us to understand. There are different principles for the application of law as well, such as Islam that we've talked about, I think, or not. Maybe then we have Ihsan is the juristic perspective. That's preference. Sorry. We have Masalaha, that is the welfare. We have Durra, that is the necessity. We have Ittisab, that is the presumption of continuity. Urf, that is custom. Takhir, that is elected choice, and we have Talfiq, and that's patching up, all of which are covered in the reading. So this is one paragraph that I took from the module. So these are covered in readings. If you want to write more about them, the application of law regarding these, you can. So I think I'll discuss a bit about istihsan and istihsab later on, but just like a paragraph, that's it. Okay, so concept of ijtihad, is a lot in this, so that's the reason I just like put down nature of ijtihad, necessity of ijtihad on a other account, and is the gate of ijtihad closed. So these are the four main questions, I guess. These are the four main topics. I'll go through them now. So let's starting with nature of ijtihad. It is based on individual reasoning. We've understood that ijtihad is based on individual reasoning. Because the divine sources are over, this is now human thinking, interpreting law, Quran, Sunnah, everything. And this is further from the divine inspiration. Ijtihad only makes an existing law clearer because it presupposes that the law is already made. Now, this is actually pretty simple. This is Ijtihad considers that there is already an existing law, right? Uh, Regarding alcohol, that is the wine, that law is already there, right? Regarding your stipulations in contract, that law is already there. So when we talk further into um, if somebody has committed fraud, right? An extension of it. The point was that you have to abide by your stipulations. Now I'm just trying to make a scenario and just listen to this a bit carefully, I'd say. So the law already exists regarding stipulations. We're extending the arm for stipulations into fraud and saying that if you don't abide by your stipulations, that is in a way committing fraud. And that is also not allowed in Islam. That is ijtihad, extending it, all right, which is already there. So that is the based on understanding of the existing law already present. For tradition, some school of thought, all the main Islamic law principles were settled around in 10th century, and thus the doors of Ijtihad are closed around this time. Around this period of the following what has already been settled is settled. That's your traditional view, your traditionalist view of looking at Ijtihad. This is what I was talking about. Prior again, that traditional would say, okay, we have the Quran, we have the Sunnah, and that is it. No need for Ijtihad. There is no need to extend anything. But then questions will come, and a rationalist, which I concur to as well in a way, that a rationalist would say that there are other things popping up. And of course, there are extensions to what is already there, but then you need to consider ijtihad, right? Because that's necessary. Um, for Shia school of thought, ijtihad became a very important source after the seclusion of the 12th Imam. However, like the Sunnis, the door of ijtihad were closed around the 10th century, though. Necessity of the ijtihad. For contemporary jurists, the door never closed, right? They believe that ijtihad should be employed to adapt to modern times. Example, this is example that's Egypt's testamentary disposition reforms of 1946. So verse 180 of Surah 2 of the Holy Quran enjoins Muslims when they are approaching death to make bequest in favor of their nearest kinsman. There is a difference of opinion on this verse, right? On another account, so this talks about succession actually. On another account, legislative ijtihad was the reason given by the Tunisian reformers when prohibiting polygamy. I really like this, and I think this example is quoted a lot. That the memorandum accompanying the Tunisian law of personal status in 1956 states that the juristic basis for the reforms was the Quran itself, as Surah 4, verse 3 of the Quran provides that a man may marry polygamously only where he is able to deal equally with several wives. That's the four wives, right? While the verse 129 of the same surah, which is Surah 4, so that's first was the verse 3, and now this is verse 129, however, states that however hard a man tries, he will never be able to treat several wives equally. Because later on it says, because it's only the Holy Prophet, peace be upon him, which is like that's the continuation. That it's only the Holy Prophet, peace be upon him, that can actually treat the wives equally. That is it. So this was one basis that the Tunisian law reformers gave, and saying that polygamy is not for us. It's not. Um, it should be banned and it should not be allowed. It should not be practiced amongst Muslims, and that's the reason they had that ban. Interpretation of these apparently contradictory verses in traditional jurisprudence was that as long as a man dealt equally with his wife in practical matters such as maintenance, housing, spending time equally between them, he had fulfilled all the obligations imposed upon him. The Tunisian lawmakers rejected this interpretation and adopted the interpretation advanced by the 19th century Egyptian jurist Muhammad Abduh, that the two verses read together amounted to a prohibitory of polygamy. So you can write that how traditionalists approached it and how rationalists approached it. On this, I'd go with the traditionalists, saying that, no matter how hard a man can try, he is not going to be fair or equal, and it will be very difficult. So that's it. And another tentative example of the use of ijtihad Now, these are the things you can mention in Ishtihad. This is for the essay on Ishtihad completely. Is that Supreme Court of Pakistan, um, in this in deciding the case of Khurshid Bibi and Muhammad Amin. So this is PLT 1967 SC 97. In its decision, the Supreme Court gave a new interpretation on the verse of Kul, which effectively gave the court the right to grant a judicial Kul. Now, the question may come, what is Kul? Kul is asking for divorce from your husband when your husband is not giving you a divorce. So the female, the wife, can ask for divorce from the husband without his consent if he is not giving you consent. And you have legitimate right, claim, reason that you want this pull, that you want to separate from your husband, and your husband is not allowing you. You are not in a captive situation with him for the rest of your life. So a female is given the option of kul, that she wants to get out of the marriage. She forgoes um, some of her finances, some of her financial assets, and she gets out of the marriage. So that's how it is. So in this case, Ishtihad was done in a Supreme Court, and it came out that a court can also give you a call. That if you approach a court, a female approaches a court and she can ask for a call, which is also a khula in Pakistani words. And this was actually taken further, a very, very, very step further. I'd say an interesting use of this judicial ijtihad was in the judgment of Mr. Justice Rabbani in um, Muhammad Hafsur Rahman and Samsun Nahar Begum, 15 PLD 1995-34. So in this judgment, the learned judge reinterpreted the Quranic verses to mean that a woman was actually entitled to receive maintenance as long as she remained a divorcee until she remarried. The traditional interpretation is that following the divorce of a woman will receive maintenance only while she's observing iddah. So you see, she is even given maintenance after she is asking for divorce from her husband. So she has a lot of rights regarding that, and then she can ask for maintenance as well if when during the time that she's observing iddah, which is after even when you're taking a call, you observe an iddah after call, and then she can ask for maintenance, of course, on legitimate grounds if he was abusive and he didn't pay her and then he did not keep her in a good financial position and stuff like that, maybe. Um, so she can still ask for maintenance until she actually remarries. So that's a very, very lenient interpretation to it. So, who can undertake ijtihad? The one who undertakes ijtihad is called a mujtahid. It's a very easy term. And the last one would be, is the gate of ijtihad closed? Now, after all the information that I've given you on ijtihad, and that's a lot of information for a very good 70 answer, with the Supreme Court cases, with examples, and with the verses, and with the Quranic verses as well, I think you can come up with a very good answer of your own. Do you think like a traditionalist or do you think like a rationalist that the gate of ijtihad is closed, yes or no? And that is your answer to give. Okay, so we have a concluding slide here, but let me just, because I did mention that I will come on the points of istisan and istisab. So, istisan is a legal rule derived by chaos, and chaos could be at times lead to unattractive results, right? So, the Hanafi school developed the principle of istisan, which is a juristic preference. So, it is allowed that a jurist to accept a rule that, in his opinion, would produce like better results. So, jurist that is um, a well-read Muslim scholar would, come up with a better understanding of a principle. And Istisan is mostly confined to the Hanafi school of jurisprudence. The Malikis developed a similar principle of equitable jurisdiction that they termed as Istisla and Masala. So that's there. School of thought, two principles. We have istisab. Now, this is presumption. It is often referred to as a source of law, but perhaps it would be better classified as a presumption of evidence. So, how this is that, let me elaborate this further. As something that holds true until it is rebutted, right? Or proven otherwise. Istisab, which is particularly prominent in the doctrine of Shia. This is also seen in chapter 11 in inheritance. But what I mean by this is that if something has not been proven to be wrong, it can be taken as right. So one example that comes to mind is very easy, very simple, and that is if someone is saying that someone has not been found for the last 10 years, right? Um, because he's not been found for the last 10 years, there is this idea that he's no more amongst the living, right? So until and unless he comes back, the idea is that he is no more living in the world. So that's istisab, that until and unless it's rebutted, it's a point of evidence. Okay, for those who just wants like other brownie points and other information. I think that's pretty much it. So let me recap some of the points because I have a entire list, which was let's start with uh, the recap would be that how Islamic law is an integral part of Islamic society and it is derived from religious sources. Understanding the origins, sources in Islamic law is essential for comprehending its impact on Muslim society, right? Then we have the importance of understanding Islamic law, which is Islamic law plays a vital role in shaping the lives of Muslims across the world. It influences various aspects of our lives, including with personal, social, economic, religious, contract, that's social, and all of these dealings, right? The origins of the Islamic law are from pre-Islamic Arabia, that's the Arabian Peninsula, all of that. Um, the emergence of Islam came in the 7th century, that's 7 AD, with the teachings of the Holy Prophet, with the Quran, right? The Quran and the Sunnah, the Hadith. The Quran and the Hadith, they are the primary sources of Islam. That's the primary sources of Islam. Quran, the words by Allah, conveyed to the Holy Prophet, revealed to the Holy Prophet through his angel Jibreel. Hadith, that is the second most important source of Islamic law. It consists of saying, actions, teachings from the Holy Prophet himself and recorded by their companions, right? By his companions. We have sources of Islamic law, that is the Quran, the Hadith, Ijma, Qiyas. Quran and Hadith, they are the main, your primary sources. Quran contains various verses on guidance on social, moral, and legal issues. Hadiths are the numerous sayings of the Holy Prophet, and they provide insight of Islamic law. Ijma is the consensus of the Muslim community of the Ummah on a particular issue. Qiyas is the analytical reasoning that involves your application of mind and legal principles existing of Islam. like law into the new situations based on analogy. The last is the evolution of Islamic law, which is the early period, formative period, classical period, modern period, all of that. And there is further discussion on school of thoughts, which is that. Then there we have also influences of other laws on Islamic law, and we have the school of thoughts, the jurisprudence, which is the development of jurisprudence, which is Sunni schools of thoughts and Shia schools of thoughts. Now, all of these things, I will mention them in the next video because this video is, I think, lengthy enough and it has a lot of questions which are already there regarding ijtihad and primary sources on all of that, the sources and the coming of sources to Islam. So I guess that's pretty much it for this video. Thank you for your time. Thank you for your attention. And please like and share and subscribe. And if you have any questions and if you want more examples or if there's anything you want, just comment and I'll get back to you. Thank you.